the question is, could it then be said that considering that it's an intra-court appeal, it's not an appeal in the appeal sense? That's exactly what the judgments say. It's not an appeal, it's an internal arrangement of the court. Could it then pass under the term practice under 191 to have this intra-court appeal, as you mentioned earlier? So that's why, is there any significance of the word practice and whether intra-court appeal is for an internal arrangement of the court and not to be considered as a substantive separate appeal?
My Lord, this is a question which to a certain extent has been answered by an opinion of Justice Munib, and I'll straight away come to that. Those are three. There is a short order by Justice, it is Justice Mandokhail who actually raised this very important issue through a short order, and then there are two opinions, one by Justice Hassan Azhar Saab, one by Justice Munib.
You might consider these three judgments of the Lahore High Court.
Yes, I can, but let me just read those because those are actually with reference to this particular case, if I may come to those judgments. And those deal with both issues, one of competence of appeal and intra-court appeal. Both have been dealt by the two separate opinions. If your Lordship will kindly see
that was without my opinion. Without my opinion.
लेकिन सर आपके सवाल की वजह से डिबेट शुरू हुई. आप सवाल नहीं पूछते.
Actually, this should have been that I should have been asked what is your opinion. Without my opinion, it was said to.
लेकिन सर आपके खिलाफ जवाब देके भी आपके हक में जवाब दे दिया, वो देखिएगा आप जरा पेज 9 पे.
चलो मैं उसका जवाब अभी जो खत्म होगा तो उसमें दे देंगे.
Sir, page 9 of the paper. Now, these are three unreported orders, my Lord, but I think these are such crucial orders should be. If I may first to Justice Mandokhail's very interesting question, which he's been constantly raising in these proceedings. If I may come to page 9, and I'll read from the second paragraph, para 2, fifth line. The question which needs consideration is whether a remedy of appeal could be provided to an aggrieved person either through an ordinance or parliamentary legislature in respect of matters decided under the jurisdiction conferred upon a court under Article 199 of the Constitution. Reference is made to the order dated 13/4/2023 passed in Constitutional Petition 9 of 20. This very petition, relevant portion whereof is reproduced above. I'll leave the portion, I'll read the last 4 lines. As the issue involved is in this petition is identical to the issue involved in constitutional petition number so and so, therefore let it be placed before the Honorable. Now, on this, a dissent was done by Justice Hassan Azhar. Very interesting opinion, my Lord, page 12, if your Lordship may kindly see. Now, the main thrust of this opinion is on that this question did not arise in the case. That is why the case was really decided on the merit. There's a very important paragraph on this intra-court appeal, which is at page 17, para 14. It's the same it is the same line of argument which Justice Mazhar had alluded to yesterday. Para 14, page 17. As far as the question of whether a remedy of appeal could be provided to an aggrieved person either through an ordinance or parliamentary legislature in respect to matters decided under the jurisdiction conferred upon a court under Article 199 of the Constitution is concerned. So both constitutional forums, intra-court appeal in the law reforms order. I am of the humble opinion that Article 175 of the Constitution by its clause 1 ordains that there shall be a Supreme Court of Pakistan and a High Court of each province, and recognizes that such other courts as may be established by law. Clause 2 of that article provides that no court shall have any jurisdiction save is or may be conferred on it by the Constitution or by or under any law. For the above question, it is sufficient to say that the Supreme Court of Pakistan and the High Courts have been established by the Constitution, that they have such jurisdiction as has been conferred upon them by the Constitution, that they have also such other jurisdiction as is or may be conferred upon them by or under any law. The expression law here has been used to distinguish it from Constitution, which is higher in authority and obviously means an ordinary or sub-constitutional law made in the exercise of the powers granted by the Constitution. Reference in this regard may be made to the judgment of this court in the case of Brother Steel Mills Limited versus Mia Ilyas Miraj, PLD 96 Supreme Court 543, wherein the provision of Section 15 of the Code of Civil Procedure Amendment Ordinance 1980, which also provides the right of appeal to a bench of 2 or more judges of a high court from an interlocutory order made by a single judge, that court in the exercise of its original jurisdiction has been interpreted by a 5-member bench of this court. Even otherwise, no provision of the Constitution places such bar on the power of the legislature. Both under 199 and 184.3, there is no bar that a right of appeal through a statute cannot be provided. Now, your lordship may note 2 things about it, and I'll come back to this. The first is that legislative competence here has been placed on Article 175(2). That's the first thing. Number 2 is that it has been held that even if the order is from a constitutional forum, as Justice Mandokhail had pointed out, even then an intra-court appeal can be provided through an ordinary statute. Now, it's very interesting how Justice Munib deals with this, because he extends the notion of legislative competence and agrees with Justice Hassan Azhar Rizvi on the issue of the Law Reforms Ordinance. Page 20.
As a referee judge.
Ji?
As a referee judge, you
Sorry?
Referee
judge, sir. Page 20, sir. I may read. Para 3 में जरा context दे दूं. On hearing the matter, a different opinion arose between the learned members of the bench on a point that was, it appears, framed by Jamal Khan Mandokhail, his lordship, expressed doubt whether a right of intra-court appeal could be provided by ordinary statute, like the ordinance against a decision of a single judge of the High Court, exercising jurisdiction under Article 199. Reference was made to certain pending petition filed under Article 184.3 of this court. Now, let me come to para 4. A difference of opinion has, next page, has arisen in my view. The question of law requiring resolution is as follows. Can the appropriate legislature provide by ordinary statute for a right of appeal against a decision of a single judge of a high court exercising jurisdiction under Article 199 of the Constitution, such that Section 3 of the ordinance is a valid legislation? Now, as far as where does legislative competence come, or how is appeal in terms of legislative competence to be framed? Very interesting paragraph, para 9, page 23 of this opinion. If I may read